Well, welcome everybody to our seminar in CLE today, thinking about the unthinkable, appellate preparation before and during trial. I am Steve Wells, and I'm here with Tim Droske, who is on my far left. We are the co-heads of Dorsey's appellate group. You may have seen us give the Supreme Court seminar, which we do every year. But we're joined today, I'm happy to say, by Doug Lang, who is a partner in our Dallas office. Doug joined Dorsey after 16 and a half years as a justice on the Texas Court of Appeals. And before that, he was a leading luminary in the Dallas bar. He was at the firm that's now called Foley Gardier, and was, among many other positions, the president of the Dallas Bar Association. So we're delighted that Doug could somehow find his way from 70-degree weather up to our, whatever it is today, 14-degree weather, and that he can join us here today for this presentation. Doug, do you want to give us a few introductory comments?
I certainly do. Thank you very much for that kind introduction. As I went to the airport yesterday at about 1 o'clock, it was 70 degrees. The top came down on my car, and it's up to, all the way up to 40 today. So we don't know what's going to happen from day to day. As you might think from looking at your handout, which is 20 plus pages, we're going to heap detail on you, but that's really not what we're aiming at. The detail is necessary, but what we're going to talk about is where you're headed in litigation, starting with when the deal blows up or there's an injury, all the way through appeal. And we're going to talk about the long haul and give the big picture. You know, a couple of things I'm reminded of. I don't really delve into Confucius, but it did occur to me that Confucius said, a man who does not plan long ahead will find trouble at his door. Well, that's, you know, fairly rational, but a lot of people don't think about it. Not quite as erudite as him is a philosopher by the name of Yogi Berra, and 19 years with the Yankees Hall of Fame during the Roger Maris and Mickey Mantle era. One of the things he said, of course, was that when you come to the fork in the road, take it. But one of the things that I've heard that actually makes sense when you think about it, if you don't know where you're going, you'll end up someplace else. So that is where I start after 16 and a half years seeing people in cases apparently not know where they're going. And we know we're speaking, preaching to the choir here, but I think a checklist, the kind of thing that we're looking at that is a timeline of a case, kind of like this, 6 different areas. Before the suit is filed, the lawsuit, when it's filed, the mid-course correction, trial preparations, error preservation, what about arbitration, and then the appeal. So there are pull downs on your pages, but we're not going to read those to you. I know you'll be relieved to know that. Tim?
Sure. So one thing that we're really trying to emphasize today is the importance of thinking about the appeal early on in the case. It's where cases end. Normally after final judgment, you know, whichever party is lost has the right to an immediate right to an appeal to the Intermediate Court of Appeals. But if you wait until that point in the case to start thinking about the appeal, you're going to find yourself at a disadvantage. And so here are a few kind of the key problems with waiting until final judgment before starting to think about the appeal. The first one is failing to make, preserve, or properly frame compelling appellate arguments. Now, any trial attorney who's actually headed into trial after summary judgment always has this at the forefront of their mind. I know the things that I want to object to, but what do I need to do to make sure that I've adequately preserved that issue for appeal, both in the heat of trial itself and then in post-trial motions. So that fear of the appeal certainly comes on strong, I think, when you're at the trial stage. But it's important to be thinking about that earlier on. And we'll certainly talk about kind of basic principles for issue preservation in the trial process and post-trial motions at the end of our seminar here. But one reason why it's important to be thinking about appeal early on is not just to preserve the objections and the issues that you know you want to make on appeal, but to even know what issues you should be bringing into the case early on so that you can make them at the appellate stage if your case gets that far. And so some ways that this comes up, in district court, the litigation is often very much focused on the facts of the case and the specific dispute between those two parties, whether that's a breach of contract action or a personal injury case or whatever it may be. The courts of appeals, though, are thinking about different kinds of issues. They're focused on rules of law, setting precedent, and determining issues that are going to have an effect not just on the two parties in that case, but on other parties going forward. And so it can often be the case that a discrete legal issue, and jurisdictional related issues, for example, can be a prime example of this, that really aren't necessarily on the party's radar, could be a key issue that the Court of Appeals may care about. And so you want to make sure that those issues, that they're ones that you can't raise at any point in the proceeding, that they're ones that you're raising early on. Another thing that could come up, for example, is, you may, if you're, let's say you practice in New York and you have a case in the Southern District of New York, an argument that you were considering having raised maybe has been squarely rejected by the district courts there, and the Second Circuit has thrown it out. And so you may make the judgment call, okay, this isn't even worth raising in the district court now because the Second Circuit's already rejected it. But if you're thinking about the appeal and know that the life cycle of a case can stretch on for years in civil litigation, maybe the Ninth Circuit has said something completely different on that issue. If you have any sort of circuit split and you look at that early on, that might be an issue that you want to keep alive solely in the off chance that the Supreme Court could grant review on that case in any of the 4 or 5 terms during this while this case is proceeding. And if they side with the Ninth instead of the Second, you would need to have preserved that issue along the way in order to benefit from that ruling. So those are some of the things in terms of thinking about issues early on for appeal. Another key important thing is that if you wait until final judgment to start thinking about the appeal, there's a good chance that you may fail to get key facts as part of the record on appeal. So again, it's in the district court proceeding where the facts are being brought into the case. And it's only those documents that are actually filed with the court that become the record on appeal. So in California right now, for example, with their budget cuts, they don't have a court reporter at civil hearings unless requested in advance. If you're not aware of this and not thinking ahead to your appeal, this could make or break your appeal. Because if the district court at any sort of hearing is hearing evidence, making findings of fact, making findings of law, unless those are transcribed and before the Court of Appeals in a written way, the Court of Appeals actually has nothing to review and would summarily dismiss and reject that issue. So you need to be thinking early on, if you're in California, for example, of do I need a court reporter at this hearing? Otherwise, whatever issue may come out of that hearing, you can never raise on appeal. Another thing that could come up, for example, is if you are dealing with, let's say, a government regulatory agency, and what's relevant is not just things in the Federal Register, but different online rules and directives that they may issue. Those could change over the course of a case, right? And so what might be germane to what started the case may be the rules and guidance that existed in 2017. But if those rules are revised and the website is completely erased by the time you get on appeal, the court would have nothing to review. So thinking ahead to appeal early, you could print out those web pages, submit those as an exhibit to the court, and then they're preserved as part of the record. Relatedly, other things, failing to focus on the right legal precedent, you want to be thinking early on about the Court of Appeals you're going to go to and trying to ground your legal arguments, not just in what other district courts have said, but what the relevant Court of Appeals has said. And another thing that we're going to be talking about here as well is that thinking about the appeal early on can also put on your radar different avenues to getting to the Court of Appeals earlier on in the case. Again, the final judgment rule is the general default rule, but there are a number of circumstances where you can take an appeal either as a matter of right to the Court of Appeals or petition on a discretionary basis. And being aware of those, thinking about those early, can be a real key strategic determination that you'll just lose out on if you only wait until final judgment before you start thinking about the appellate court.
I think, I think Doug said when we first started out that this is going to be about sort of thinking about where you're headed in litigation. This seminar today is really also about where your head is in litigation. Because there is a trial brain and there is an appeal brain. And it's important to understand, I think, what the differences are and the differences in perspective, because they're critical to be able to sort of turn off your trial brain and turn on your appeal brain when you are in a status prior to the actual appeal. It involves, I think, consciousness. It involves discipline. Obviously, it can be done. But in some ways, you know, your trial brain is sort of, you're in the moment, you're making decisions which can oftentimes come in seconds. You're like, in many ways, sometimes the emergency room doctor. The appeal lawyer, the appellate brain, is more like the pathologist. You may have weeks or months to make a decision or to craft your arguments. So they involve different skills and different sort of levels of consciousness and perspectives. Let's just look at a few of those here. And this is taking the general and making it specific. At trial court, and I am generalizing on some of the things that happen with respect to the trial lawyer, but I think these are generalizations that are more or less true. At trial, we're really concerned about the facts, and we're really concerned about the emotional impact and the visceral impact of the impression that we're making either on the judge or the jury, whoever the fact finder is. On appeal, it is a much more considered, slow-moving process where the focus is almost entirely on the law. Not to say that facts aren't interesting to the Court of Appeals or that they can't be persuasive, but the focus really is on the law. At trial court, you're more interested in doing what needs to be done to win the case now. And as I said, sometimes that comes as a result of decisions that are made on the spot because it's not a scripted proceeding. Again, not true on appeal. Much more of a scripted proceeding, one that will, again, take weeks or months to craft your argument or respond to your opponent's arguments. There is a theater, obviously, to trial lawyering. Not to say that trial lawyers are actors, but they are conscious of many of the things that make actors successful when it comes to creating impressions and making persuasive arguments. Again, at the appeal level, a much different atmosphere, much more academic, much more like the PhD defense. There is a real tension, I think, at trial, particularly in Minnesota. So I'm not from Minnesota, but I consider myself to be like a cultural anthropologist of Minnesota niceties. And what I've noticed is that Minnesotans hate it when you interrupt people. We're a very polite people. I've been here for 30 years, so I can kind of call myself we. We don't like interruptions. And so trial lawyers, and this is true in other jurisdictions too, trial lawyers would, generally speaking, rather not object. It ticks the jury off unless it's really important. Well, that's fine. And that may be the right thing to do at the moment, to not frustrate the judge or the jury with your trial objection. But in not making an objection, you set the stage for what can and can't happen on appeal, because if you don't object, you haven't preserved the issue. One other big difference between the trial mind and the appellate mind centers on the end of the proceeding, the jury instructions and the verdict form. The general verdict form, many trial lawyers like, particularly if, it can apply to both plaintiffs and defendants. It tends to uncomplicate things. And so if you think you're doing well, a general verdict form often is a thing that you'll urge on the court. On the other hand, on appeal, a special verdict form creates more grounds for appeal. There are more ways that you can argue that evidence was insufficient, various other things tied to a variety of issues that would come up in a special verdict form where you don't have the wiggle room that you do on in a general verdict form. We'll talk a little bit more about jury instructions later on too, but I think that there is a trial and appellate perspective with respect to jury instructions. So I think it's not that these two brains aren't compatible. I mean, one is a little bit left brain, one is a little bit right brain. What we're saying is that at moments or even throughout the trial preparation, from the very beginning of the case through trial, it's important to kind of every once in a while, maybe more often than once in a while, turn on your appellate brain to make sure you're thinking about how the very visceral, emotional appeal that you're making for trial will play out on appeal.
Before the first pleading is filed is a very important period of time because your client may know that they're going to sue or they will be sued very shortly. Some of the things that are kind of knee-jerk reactions that I've found over the years is they'll just say, well, we'll file this in Dallas or Minneapolis, or, you know, haven't really thought about it too much. Yeah, we can get venue there. We meet the due process test of minimum contacts. But it's always worth sitting down and actually going through a list like we're providing here and thinking about those things. To me, it's hedging your bets. Figure out the best place, as Tim was saying. For instance, if you're the plaintiff, what is the law in the jurisdiction on things like punitive damages? In Texas, there's a cap on it. There's a whole lot of litigation where the jury comes back and gives them more. Is there going to be a reduction by the trial court? Does it get taken up on appeal? Are they uniformly enforcing it? Statute of limitations, that can always be different from region to region, from jurisdiction to jurisdiction. If you decide on Texas or Minnesota, where are you going to file? Are there several opportunities, different places you can file? I'll give you some examples of what I've run across over the years. The Rio Grande Valley and Brownsville can be anywhere between a 10 and 12-hour drive from Dallas. You could drive up here in the same time from Dallas. It's culturally very different. It is plaintiffs oriented. People like to file lawsuits there. Jury verdicts tend to be big. The same thing is true in the eastern part of Texas. I've never quite figured that out, but the facts prove it. Federal court or state court, either way, whatever juries you get. So do you want to figure out how to stay out of there? Or if you're sued there, you want to get out as fast as you can. Federal court, you might have a choice of venue in a contract, or under 1404A, you could possibly get it moved. Getting out of the Rio Grande Valley may require an appeal to the Court of Appeals in San Antonio because the trial judge may not want it out. You also have questions in my state about the orientation of the elected judges on the trial bench. In the last, perhaps 8-10 years, there's been a lot of plaintiffs' lawyers, which is not bad, but plaintiffs' personal injury lawyers who've taken the bench. They tend to believe in letting everything in, which is what I was dealing with for 16 and a half years, should that evidence have been in. The jurors aren't quite the problem, so you need to balance those things. And then, of course, removal. In the Eastern District of Texas, you may not get a different jury, or in the Southern District, down in the Rio Grande Valley, or the Valley, as we call it, you may not get anything different, but you may get a few less laxities in the way the judge is handling things. So those things are very important, and once again, as I said before, I really saw a lot of folks who were moving too fast to consider alternatives. With that timeline we were looking at, different things need to be strategized along the way, as we are going to discuss with you.
So there are a few types of proceedings that are inherently fast-tracked for appeal because there's an exception to the final judgment rule that applies to them, where you not only have an opportunity to petition the Court of Appeals for earlier review, but there's an interlocutory appeal as a matter of right. And if you're dealing with with any of these kinds of cases, it's really important that you start turning on that appellate brain early on, or bringing on someone with a more appellate-focused practice early on in the case. The two main examples of this are injunction actions and any case involving immunity. So under federal law, and many states have a similar corollary, there's an immediate right to an interlocutory appeal from any injunctive order. And that's not just an order granting an injunction, but also one denying it. It can be one continuing an injunction, modifying it, refusing or dissolving an injunction, or refusing to dissolve or modify an injunction. What's really critically important is this doesn't just apply to the final injunction order after full discovery and a full hearing or trial. Even a preliminary injunction order, the grant or denial, can be immediately appealed as a matter of right. And for those involved in trial litigation practice, it's not at all uncommon to file the complaint and that very same day attach to it, a motion for preliminary injunction. These things happen very quickly. So what are some of the things that this means then if you're dealing with an injunctive action? Realize that record on the preliminary injunction could end up being the full record on appeal. And so whether you're trying to move for the injunction or oppose it, you need to be thinking carefully about what kind of facts need to be not just in front of the district court here, but in front of the Court of Appeals in order for them to examine and decide this issue. So, you need to be thinking very carefully about what, declarants you need, what exhibits you need to attach to your your motion for preliminary injunction or opposition to that motion, because that's going to be your record on appeal, win or lose. The other thing is that the standard for a preliminary injunction is likelihood of success on the merits. But the reality is that with there being an immediate right to an appeal, the Court of Appeals is going to be looking at these legal issues very early on. And whether it's just a likelihood of success on the merit standard, even if that's how it's framed, often that can be the dispositive legal determination of a case when it gets to the Court of Appeals. That's particularly true if the legal issue is one that's kind of a pure question of law. So for example, express preemption cases would be a prime example of this. And Steve and I were involved in one earlier on in my career here, where we represented parties challenging a California law as being expressly preempted by a federal law. We brought a motion for preliminary injunction. It was granted. The other side appeals as a matter of right. And it ended up going all the way up to the U.S. Supreme Court, with the U.S. Supreme Court granting cert and issuing its determination that the California law was expressly preempted, even though it was technically on a likelihood of success on the merit standard. It went all the way to that court and was the definitive ruling. Even if the issue for your injunction is one that is going to be more fact-intensive, where perhaps it needs to go through full discovery and a full hearing in order to really determine the merits of the injunction being sought, the reality is that if the Court of Appeals is weighing in on that, on the merits, the likelihood of success on the merits early on, whatever the Court of Appeals says is going to have significant weight on the district court when it's looking at the case going forward. So you just really need to be thinking about those issues early on and very carefully. Immunity is the other example where you have an immediate right to an appeal, even if the court finds that a party is not immune from suit. So issues where this can come up would be, 1983 actions are a common one. Another would be, we have attorneys here at Dorsey who regularly represent foreign governments that are sued in the United States. There's a federal law, the Foreign Sovereign Immunities Act, that says that those foreign governments are immune from suit here, subject to certain exceptions. We also have an Indian law practice group that represents different tribes in litigation. There's tribal sovereign immunity that the tribes can invoke in those kind of cases. And if a motion to dismiss is brought arguing immunity and the district court denies that, there's an immediate right to an appeal under what's called the collateral order doctrine. The theory behind this is that if there's an order issue that conclusively determines an issue, but it's an issue that's collateral to or wholly separate from the merits of the case, but effectively unreviewable on appeal from a final judgment, you can appeal that as a matter of right. And the courts have said that immunity is that kind of issue. The reason for that being that immunity doesn't just concern immunity from liability, but immunity from the whole legal process. And so waiting until final judgment isn't adequate relief. So if you're dealing with a case where, a government body may be able to claim immunity, know that that can go up on appeal quickly too. And so the same kind of considerations for developing that record on appeal early on, those legal arguments come to bear there as well.
One moment in the pretrial period that is ripe for consideration of appellate review is the time when you're considering a dispositive motion. So that's in both the most state rules. It's the kind of the Rule 12 stage and federal cases too, and then a summary judgment for under Rule 56, so the Federal Rules of Civil Procedure. There are a variety of legal issues, obviously, that could be brought in this context. But what's critical to remember is for most of these legal issues, if they're not preserved, if they're not brought as a Rule 12 or a Rule 56 motion, they may be considered to be waived. Now, that's not true with respect to justiciability and subject matter jurisdiction, but for almost every other legal issue, it can be deemed a waiver if you don't raise the legal argument in the context of a Rule 12 or 56 motion, or possibly at the end of trial is another opportunity to do that. Issues that regularly arise in this context are, Tim, if you want to hit that, jurisdiction, so subject matter jurisdiction or personal jurisdiction, choice of law, preemption, statutory interpretation, legislative standing, that is, are you within the class of persons that have a right of action under a statute or contract interpretation. Now, as we've kind of said before, and we'll kind of keep harping into, that the time to consider this issue, of course, is when the time for a Rule 12 motion or the time for a Rule 56 motion. But because you may have a choice as to what appellate court is going to hear those particular issues, it's also critical to think about those legal issues before you either choose your court if you're the plaintiff or consider removal if you're a defendant and you have that option. And I'll just give you an example. So there are times when there are legal issues under state statutes, and you may have diversity jurisdiction. So you may choose as the plaintiff to say, I think I'm more likely to get a better ruling from a state court, whether it's the Minnesota Court of Appeals or the Minnesota Supreme Court, on an issue of Minnesota law where they're more likely to maybe go a little further than previous cases, or where they'll feel at least the right, if you're the Minnesota Supreme Court, to kind of make new law, as opposed to going to, say, the Eighth Circuit, which is a fairly conservative circuit, and in any event, a federal circuit court is unlikely to even attempt to make new law under state statutes. And so those kind of decisions need to be made before you're going to bring your case or before you decide to remove if you're the defendant, and then they need to be made at the Rule 12 and the Rule 56 stage. And the standard of review, if you make these timely and if you make them right, is de novo. Which means that it doesn't really matter what the lower court holds, because the Court of Appeals is going to take a completely fresh look at it. You may get a second bite of the apple, even if you haven't raised some of these under a clear error standard at the Court of Appeals, but generally speaking, except for subject matter jurisdiction, if these issues aren't timely raised, they can be waived. Yeah, go ahead. Yeah, go ahead.
You had some part of this, I suppose.
Well, I just say, so one other thing I want to just emphasize slightly here is even if you think you have a rock-solid trial case, you're absolutely right on the merits, and a rather thin legal argument on a Rule 12 or Rule 56 motion. On appeal, the rule is essentially that any grounds that have been properly preserved and properly raised at trial may serve as the basis for affirmance on appeal. And so it's kind of the belt and suspenders approach. Even if you think you've got a great case, if there are potential alternative grounds that can be raised to the Court of Appeals for affirmance of your position, raise them to the trial court, because if there's error later on in your rock-solid case, these alternative grounds for affirmance may save your bacon.
The fast-track interlocutory appeal is a very important thing to consider. I've found that not that many lawyers think of an interlocutory appeal under federal law or under state law. We have that in Texas under state law as well. Well, what you have to do is a two-step plan. You have to ask the trial court if you can appeal, if that judge will actually say that it should go to the Court of Appeals. And there are three issues: that it's a controlling question of law. Secondly, there's substantial ground for difference of views and opinion. And ultimately, when it's decided by the appellate court, it could advance a termination of the litigation. So if you get the trial court to go with you and say, Judge, this is just a really tough situation, the law is unsettled, we're spending all this time and money, and we may go nowhere, and it could be just bounced immediately by the Court of Appeals and then the Supreme Court. If the judge agrees, and frankly would like a little bit of an advisory opinion, then you have to apply to the Court of Appeals in federal court and state court. But the Court of Appeals has to make the determination on these three issues as well. And they could say, no, we're not going to give an advisory opinion. This is not controlling, and we're not satisfied this is going to materially advance the disposition of this case. You could go beyond that. For instance, in our state, we have 14 courts of appeals spread out all over this huge state. And if that's denied at the Court of Appeals, we could try to go down to Austin, to the Supreme Court, and say, please reconsider this. Another point for, as I call it, mid-course correction is mandamus. I'll tell you that I did only about 2 in the few decades I practiced before I went on the bench. I didn't really think about it that much. I dealt with these daily on the Court of Appeals. Most mandamus petitions are denied because you have to show 2 things. You have to show to the Court of Appeals that there was an abuse of discretion. The judge's decision was, as some call it, outside the range of reasonable disagreement, or as a matter of law, it was wrong. And then the other crucial piece is there is no adequate remedy by appeal. In other words, if you don't fix this now, Court of Appeals, we're really in deep hot water. There's going to be a huge problem. We're going to go all the way through this. Look at the issues. Of course, if the trial court is going to wholesale allow trade secrets or privileged documentation, or narrow the scope of physical examination of a plaintiff or someone else is injured, any of those type of things. Or as I've seen with some of the things in some of the major cities in Dallas, you went from the beginning of time until now, all the records. Okay, well, frequently that's way too wide. So you go to the Court of Appeals. Court of Appeals can immediately say no. They don't have to say why. Do you want to go to a higher court? Get the Supreme Court to tell the Court of Appeals, mandamus them, you need to tell the trial court to do thus and so. There were times when I actually looked through boxes of allegedly privileged documents and made that decision on the Court of Appeals. So the judges do that. If they feel there's merit, they will ask for a response, and then they'll go forward and make that decision. It's a quick hitter. Sometimes you can get the Court of Appeals to stay the proceeding, stay discovery, or stay the whole proceeding while you're looking at this. But once again, it needs to be significant. In federal court, I've read some cases where the Circuit Court of Appeals has said, wait a minute, you didn't do this interlocutory appeal under 28 U.S.C. 1292B, where you have to ask the trial court and then you ask the Court of Appeals, because it's a controlling question. You should have done that. Well, can you go on mandamus anyway? I'd always try. So those are tools that you need to change the course if it's going the wrong way. If you can't get the discovery you want, or if the other side's getting too much and you need to narrow it.
So class actions are another kind of lawsuit where there can be a lot of appellate issues, and it's important to be thinking about appeal early on. Class certification, even though it's a dispositive type motion, it certainly doesn't adjudicate the merits in the way summary judgment or a motion to dismiss would. But it's recognized that it is dispositive in nature, because if a class is certified, the whole scope of the lawsuit radically changes from this being a one plaintiff suit to now, a class-wide litigation. And as a result, even though there's always an appeal as a matter of right from after final judgment to the class certification decision, the reality is that once a class is certified, a lot of those cases settle because the stakes are just too big at that point. The federal rules of civil procedure have provided a mechanism to petition the Court of Appeals for discretionary review of a class certification decision, recognizing, I think, that final judgment isn't always going to arrive in these kind of cases in the same way. The important thing to know about these Rule 23F petitions that you can bring is they are discretionary. So even though there's kind of an express mechanism for going to the Court of Appeals, it's not an appeal as a matter of right. And therefore, it's important that you be thinking about, in your class certification opposition, and if you're the defendant, what kind of issues may resonate with the Court of Appeals in bringing a discretionary petition. Simply saying the district court got it wrong here on the particular facts of this case, that's not necessarily raising any sort of legal issues that the Court of Appeals is going to care about, not just as to your case, but also as applied to others later on. So it's important to be thinking, when you're bringing your class certification opposition, what are some of the kind of hot issues right now that appellate courts are thinking about that will hopefully make a 23F petition, if you need to bring it, more compelling? And also, having a bead on what the Court of Appeals are saying, it can hopefully influence the district court, so you get class certification denial and don't need to bring that 23F petition. I'll get into those hot issues in a second. One thing to bear in mind is that this 23F procedure, and similar to some of the procedures that Doug was just talking about, petitions for writ of mandamus, for example, it's important that you move quickly on these. 23F petition, you only have 14 days to get that petition on file unless the U.S. government is a party to the suit. Petitions for writ of mandamus, there's no fixed clock, but it needs to be in a reasonable amount of time, and if you sit on that too long, it looks like you're just trying to stall the litigation rather than there's this real pressing need. And so you need to be able to move very quickly in getting these on file. And so it's important to be thinking about what kind of team you would want in place to get those petitions on file and what you can do to get the members of that team familiar with the issues early on so they can hit the ground running. In the class certification context, what are some kind of the hot issues that can matter and that courts of appeals and the Supreme Court are looking at? Spokio-related standing issues are really big right now. So in the Spokio case, the Supreme Court examined what the injury in fact requirement means when you have a federal statute that provides a private cause of action. Is a violation of that statute enough to give a party standing, or do they need to show that there's some sort of concrete particularized injury in fact in order for them to sue? This is being thought about in the district courts and Court of Appeals, and the Supreme Court has yet to still kind of give its answer to what the standard actually means. So those kind of issues are ones to be thinking carefully about. Nationwide class actions where members of the classes may be subject to different state laws. For example, if you're dealing with mortgages where it's the wherever the home is the state law that's going to apply. Those can present issues in terms of manageability, also questions regarding the predominance requirement, and those are things to be focusing on in class certification opposition. Personal jurisdiction requirements are also kind of one of the new issues that's now hitting the Court of Appeals. The Supreme Court a couple years ago in the mass tort context, said that every plaintiff needs to be able to show that there are sufficient minimum contacts with respect to the defendant in the venue that you're in. The question being litigated right now in some of the Court of Appeals is, does that apply to every unnamed putative class member as well? So if you're not just suing in the jurisdiction where there's general jurisdiction, you need to show minimum contacts as to each unnamed class members. These kind of things are things to be thinking about, especially if you think a 23F petition may be on your radar. And, you know, the courts of appeals are things to be thinking about in terms of settlement as well. And class actions, again, are kind of a prime example of this. Class actions settlements need to be approved by the district court and can be challenged by dissenting members. So the Supreme Court last year was taking a look at Cypress settlements, for example, ultimately remanded the case on Spokio issues. But you need to be thinking about the jurisdiction that you're in terms of whether the circuit court would be favorable to Cypress settlement, claims made settlements, what degree of scrutiny may the Court of Appeals and the district court apply to whether the class certification requirements are met, even if you're bringing a settlement class. Those are all things to be thinking about. And like Steve mentioned earlier on, outside of the class action context, looking ahead to the Court of Appeals can also matter in terms of your settlement calculations. You know that there's been a huge change in the composition of the federal courts of appeals under President Trump's administration. And in local jurisdictions, as Doug was saying for Texas, and is also the case in Minnesota, there have been a lot of changes to the composition of the Supreme Courts in those states as well. So when you're looking down the pike in terms of where the case may be headed, those considerations may come into play in terms of when and if to settle. Doug had also talked about, when he was talking about mandamus and certification, that those are avenues for taking discovery challenges to the Court of Appeals. As a general matter, if you're appealing for the first time from final judgment in the case, whatever happened in discovery usually is not going to be an issue in the Court of Appeals, even though that's where years of litigation is often expended and certainly an important part of the district court proceedings. At the Court of Appeals, the discovery fights, they don't go directly to the dispositive merits of the suit. They're all subject to an abuse of discretion standard, and again, seldom are kind of the key issues to be raised at the Court of Appeals. But there are certain kinds of discovery disputes that come up that may be ripe for trying to take an interlocutory appeal. Privileged communications would be a key one. If you've withheld documents claiming an attorney-client privilege and the district court has ordered them to be produced, you could try to bring a petition for writ of mandamus, or first try certifying an appeal. The key thing in both instances will be, I think, that if it's just grounded in the facts of that case, it's going to be less likely to get the Court of Appeals' attention. It's much more compelling if you can ground it in a question of law. As a matter of law, in these kind of circumstances, does the attorney-client privilege attach, or has it been waived? It's also important to think about, between certification and mandamus, that what your papers are going to look like are going to be very different. If you're applying for certification, you're bringing petitions, which are kind of a tease as a sort that kind of explain what the issue is, but if you grant it, then we'll give you the full briefing. If you're doing a petition for writ of mandamus, that petition also needs to not only be your compelling piece of paper for why mandamus should be, why the court should look at it on an interlocutory basis, but also needs to include your full merits argument as well. And so it's a much more fulsome paper and requires more time and effort as a result in many circumstances. In addition to privileged communications, physical examinations would be another example of a kind of discovery-related proceeding where you could get an interlocutory appeal. Again, I think the key thing here would be thinking about how can you ground it in more of a legal question. Has someone's physical health or mental capacity been injected in a lawsuit when under these circumstances as a matter of law, as opposed to just saying, in this particular case, this is going to be really intrusive. So those are the things to be thinking about for preparing for appeal in discovery.
Arbitration. Do you want to do it or not? One of the things that we've talked about over in the past few months is that different types of arbitration clauses may be suited for different situations, so that when the deal is being put together, it might be helpful if trial lawyers, appellate lawyers are looking at the arbitration clauses put in. Some people, over the years, and I don't blame them, but they just put the same clause year after year and deal after deal. But what do you want to arbitrate ultimately, and do you want to arbitrate? The first step in this is to be sure you don't waive arbitration. The standard is whether you have substantially involved or engaged in litigation practice. If you've done discovery, motion practice, waited a year, and then file your motion to compel arbitration, the court may say it's too late. You've substantially engaged in this litigation. We're not going to allow it. Well, of course, that may be a point on appeal, but we're not going to allow it, and it's denied. The second thing is to consider if the arbitration clause is actually enforceable. It's the movant's burden to prove prima facie case that you have an arbitration clause that it addresses the issues you want to arbitrate. But the respondent can raise any affirmative defense that you could under any contract situation. Fraudulent inducement, there's no agreement to begin with, the issue that movement wants to arbitrate is outside the scope of the clause. A whole menu of things that could be raised. The Supreme Court decided in 1967 the Prima Paint Corporation case, and they succinctly pointed out the three issues of disagreement. Merits of the dispute, what are they? Identify those. Whether the merits are subject to arbitration, and thirdly, who decides the second question? Does the judge decide? Does the arbitrator decide? Now, early this year, in January, the United States Supreme Court decided a long-running disagreement amongst the circuits about who decides. They said in the Henry Schein case, Henry Schein versus Archer and White, they said, look, if the arbitration clause says that the arbitrator is going to decide arbitrability, in other words, are these issues the ones that are going to fit into this arbitration clause, then the court needs to stay out of it. So the arbitrator becomes the gatekeeper on that one, and in other cases, the trial court is the gatekeeper. That is something always to be aware of and to be very careful about.
So let me talk just for a few minutes about issue preservation at trial. My experience has been that if you lose at trial, but want to raise an objection to evidence or experts or something like that, the Court of Appeals, whether it's federal or state, will generally seize on any argument for waiver that it can. And that may be a cynical view, but it's sort of the practical view of how I think courts look at trials, particularly if it's a jury decision and the jury came out against you. So what that means is, and if we could see the, hold down here, there are some general principles that you just have to follow as a trial lawyer during trial. You need to object to preserve the issue on appeal. And the second related point is you should be objecting essentially at every possible opportunity. I recognize that is in tension with my observation of that Minnesotans and certain other polite peoples don't like to be interrupted. But if you want to preserve your objection, you have to do that. And it's important that the objection be timely and that it be complete. So one trap, for example, is lawyers bring a motion in limine with respect to evidence and try to get evidence excluded prior to trial and lose, and then fail to renew the objection at trial when the evidence is actually coming in. Depending on your jurisdiction, you may have waived that argument even though you brought it as a motion in limine. So the good practice is if you know evidence is going to come up that you're going to object to, bring it in a motion in limine, and then when the evidence is offered at trial, you should object again. The objection has to be detailed enough so that a reviewing court can see that you objected specifically and that you asked for what you wanted to happen. So if you're objecting to the admission of evidence, you're clear about that. The other thing that's critical is that the objection be on the record. So it's not good enough if you're at trial to talk to a trial judge at the bench that's not being recorded about your problems with some of the evidence that the other side wants to get in. It absolutely has to be on the record. There are, on the right-hand side of our slide, these are kind of classic things to object to during trial. Dispositive legal issues, even if they've been raised, again, in a motion in limine or a motion for summary judgment prior to trial that was unsuccessful on your part, they should be raised again at trial. The outcome of whether you object kind of depends on your jurisdiction. But I think the mantra of object at every opportunity to object is the correct one. Evidentiary rulings are reviewed for abuse of discretion. So again, evidentiary rulings are kind of the classic things that you object to at trial. One thing that I think a lot of lawyers may not do correctly is they'll bring, again, a motion in limine, maybe a Daubert motion, to try to exclude expert testimony. And then when it's denied and the expert testifies about the very things that you object to, you don't continue the objection during trial. And you may have been deemed to have waived it if you do that. Similarly, with attorney or juror misconduct, that is an objection that has to be raised at trial, or a court of appeals may well say it's waived, even if it's egregious attorney misconduct. Now, that's not a hard and fast rule. Judges on appeal can still look at the circumstances, so it's not black and white. But your chances of preserving an attorney misconduct or a juror misconduct argument will be much greater if it's made at trial. Similarly, with a special verdict form with jury instructions, those have to be made at the time of the charge conference or before the case goes to the jury. Sufficiency of the evidence also, again, raised if you're the defendant, at the end of the plaintiff's case and at the end of your own case. On counterclaims, plaintiff should be making the argument at the end of defendant's case. Whenever you can object, whenever there's an opportunity to object, you should object to preserve the issue for appeal.
Expert witnesses. First thing, of course, is to determine, do you need one? Will your opponent need one? Will they think they have to have one, even though it may be an issue that will be opined about that's within the realm of experience of the jurors or the trial judge and don't need any help? But that has to be determined strategically at the beginning and decide what the issue is. Rule 702 of the Federal Rules of Evidence, as well as most of the rules in state practice, require that the expert demonstrates scientific, technical, or specialized knowledge that will help the trier fact, that the testimony is based on sufficient facts or data, it's the product of reliable principles and methods, and finally, it has the expert has reliably applied the principle and methods to the case. Well, that all sounds very reasonable, but if you have a case where you're saying there was no evidence, but there are experts who have testified in opposition to you, you have to show that they absolutely did not conform to those requirements. It was the Latin phrase ipsi dixit. He himself said it. In other words, believe me, I know, this is it. And there are plenty of cases out there that go right to the heart of that right away. So that is a very careful consideration, and be sure. And as Steve just said, you can make your Daubert motion and try to get those experts knocked out. You must object at the time of trial if the judge is going to let them in. You must bring that up in your your pre-submission to the jury motions, your post-judgment motions, and highlight it for the court when you're taking it to the court. And don't just say there's no evidence. Say there's no evidence, including no evidence by virtue of this expert opinion. And here's why.
So next, preparing for appeal and trial with attorney misconduct. Attorney misconduct, if it's an issue that you're raising for the first time in the Court of Appeals, or where the district court found no attorney misconduct existed, it's going to be very hard to get the Court of Appeals to bite at it and take on that issue. But it's an important issue to be keeping in mind, especially in post-trial motions. If you know the other side's attorney was acting improperly, and you can get the district court in a post-trial motion to find that, you can get a new trial order that's going to be where the Court of Appeals is generally going to be very reluctant to overturn that issue. And another key thing is there's generally no immediate appeal as a matter of right from a new trial order solely on the basis of attorney misconduct. So you would have your do-over first before the case would ever get to the Court of Appeals. So this one is very important to be thinking about, I think, especially at the post-trial phase, because it can do a lot to insulate yourself on appeal. It's an important way to just get issues before the district court one last time. Like Steve said, all the general rules of thumb for properly objecting to make sure you get any instances of attorney misconduct before the judge during trial are critically important in order for you to be able to show that you adequately preserved that in your post-trial motions. But just keep that issue in mind as one that you can raise.
So we talked a little bit about preserving objections to jury instructions, but there's another side to this too, and that is crafting your jury instructions in a way to make them as appeal-proof as possible. And I think too often trial lawyers, and I think all of us who try cases have been guilty of this at one point, tend to take the standard jury instructions, whether they're state or federal, and try to juice them up a little bit in a way that makes them favorable and applies to the facts of the case. And there's nothing wrong with doing that, except that the further you get away from the general instruction guides, the higher the risk that an appeal court, who's going to be looking at the jury instructions de novo, may say you went too far. And so trying to be too clever, too cute with the law, plucking a statement out of a Supreme Court case and sort of plunking it into a jury instruction because it seems like a favorable thing to tell the jury can have its dangers too. And my advice and what I would implore trial lawyers to do is when you are crafting jury instructions, obviously craft them well ahead of trial. And when you're crafting them, consider how they're going to look to an appeal court that is going to be comparing them likely to standard jury instructions. Does it look like, do these look like the standard jury guides on steroids, and is that going to cause a problem for you on appeal? The verdict form is another consideration that when you're crafting, again, kind of the same principle involved here. As I said at the outset, general verdict forms are useful because they're harder to appeal. There's a lot of things that can be swept into a general verdict form that just asks if, I'll just take the personal injury context, is the defendant liable, and if yes, were there damages and for how much? That would be kind of the simplest form of a general verdict form. The decision whether to go with a general verdict form or whether to use a special verdict form that breaks out, for example, all the elements of each cause of action is obviously a judgment call, but it is easier to appeal a special verdict form than a general verdict form. And how that cuts in your particular case and whether you're the plaintiff or defendant is entirely a judgment call based on the facts of your case. But it's important to consider the appealability of the use of both of those forms because they really drastically differ in how the Court of Appeals will look at it.
Preparing your appeal in post-trial motions, well, some of these motions that you have to really look hard at are before they go to the jury. You have a motion for judgment as a matter of law, frequently called the motion for instructed verdict or directed verdict. And what you're saying there is there are no issues of fact here. The other side didn't come forward with anything. As a matter of law, take it away from them, Judge. I think most judges are, in my experience, reluctant to do that unless it's just crystal clear. But this also becomes a matter of important procedure as well as process. In most state rules, at least what I'm accustomed to dealing with under Texas law, you've got 30 days after judgment is rendered to file various post-judgment motions. If you have a motion for entry of judgment on the verdict or judgment for, a motion for judgment notwithstanding the verdict, of course that has to be filed after the verdict is filed, but before the judge renders the judgment. Under the federal law, you've got some 28-day requirements. If you made your motion for judgment as a matter of law before the submission to the jury, and you're saying that there was no evidence, you would need to follow that up with another one. But after the jury has made its decision, you got 28 days. 28 days, not 30, 28 days. Motion for a new trial within 28 days. You've got motion to alter or amend, 28 days. Those are odd numbers because your time for appeal is 30 days. But some of these motions will hold in abeyance the running of that. Also, it is something I saw a lot is that people might denominate in the trial court an error, an evidentiary error, or an error in the charge or something else, and fail to tell us how that was harmful. How did that bring about the rendition of an adverse judgment? It's critical because those two things go hand in glove. You need to give the trial judge an opportunity to make it right, just like you do in trial with your objections or motions. Bring it to the attention of the judge so the judge fully understands what's going on so the judge can deal with it. But in the motions, certainly the same thing is true. And then your Court of Appeals will look at all of those things. What is the standard of review? Is it as a matter of law, as I was saying with the motion for judgment as a matter of law, in the motion for a new trial or other things? Is it abuse of discretion on an evidentiary issue? Was the judge deciding something within that range of reasonable disagreement, or as a matter of law, was she wrong? Then the Court of Appeals will be looking at those standards precisely. You have to focus in on those things, so focus in on them when you're in the trial court, because without that focus, things will get lost in the shuffle.
I think we'll just have one of our next CLEs focus more on preparing for appeal on appeal, because that's certainly its own topic. But just know that there's a lot. When you get to the Court of Appeals itself, you have this challenge of taking years and years of litigation, hundreds of pages of motion briefing, thousands of documents, and condensing that into a 50-page brief and identifying a few key exhibits that explain to the court enough so they have a sense of what this case was about and can also be the ultimate deciders of the case. You need to both understand it and you need to educate them on the issues. You need to narrow the issues. The court is going to hone in on the hard questions, so you need to be able to know how to respond to those. And your ultimate job on appeal is to try to make this case easy for the court. How can the Court of Appeals sleep well at night knowing that they found for the right rule of law applied to this case that's going to have sound policy impacts going forward for other future cases, and made it easy for them to reach that right result. So thank you everyone for coming. We'll be here for a few minutes if anyone has questions. Thanks a lot.
Thank you.